you're telling me that I can get someone who owes me rent arrested? Ooh. Contempt of court proceedings in small claims court. What is that? If you've used Openroom, there's a good chance you've been through this exact pattern. Maybe you're a landlord with an order for unpaid rent or damages. Maybe you're a tenant, actually, with an order against a landlord for things like a refund of rent, an illegal eviction, or interference with their reasonable enjoyment of the unit. Either way, you went to the landlord and tenant board, you got an order for money, and then you converted it into a small claims court judgment because the money still wasn't coming in. How are you going to get it back? So now, on paper, you have a judgment. The court said you are owed the money, but the money still isn't coming. Today's video is about one of the most misunderstood tools in that process, which is the contempt of court in small claims court. Hello, my name is Weiting, Bollu, and I'm the CEO of Openroom.ca. Today's video is made in partnership with CourtReady.ca, which builds practical tools and lessons for self-represented litigants across Canada. So today I'm going to walk you through the rules step by step so you see what your options really are. And I'll be very straight and upfront with you. Contempt of court is not a magic wand for enforcing the other party to pay. The law is actually pretty clear on that point, and I'll come back to it. But contempt does still have a role in the enforcement process, and understanding that role is the difference between using the system effectively and then burning months of your time chasing the wrong remedy. Part 1. How do you get there in the first place? Let's start with the step that comes first, because contempt in small claims court is almost never a standalone thing. It's a consequence of something else. Under Rule 20.10 of the Rules of the Small Claims Court, when there's default under money order, you can ask the court clerk to issue what's called the Notice of Examination. That's the Form 20H. Then that notice gets served on the debtor and in plain terms requires them to come to court and answer questions under oath about their finances. We've made a video on this, so check it out. What can they be examined on? Actually, quite a lot. The reason for non-payment, their income and their property, the debts they owe and the debts owed to them, any property they've disposed of before or after the order was made, their past, present, future means to satisfy the order, whether they intend to obey, and any reason they might have for not doing so, and any other matter pertinent to enforcement. If the debtor is an individual, they also have to fill out a financial information form. That's Form 20I. They have to serve it to you, they have to give a copy to the judge, and they have to bring documents to back up everything that they have put on the form. The examination itself is held in private unless the court orders otherwise. It's conducted under oath and it's recorded. That's the examination. So what happens if the debtor doesn't cooperate? That's where Rule 20.11 comes in. Part 2, Rule 20.11, step by step. Let me walk you through this. And this is where the contempt enters the picture. It works like a sequence. Step 1. The trigger. There are exactly 2 ways a contempt hearing can be ordered. Either the debtor was served with a notice of examination, showed up but refused to answer questions or produce documents, or the debtor was served and just didn't show up at all. If neither of those things has happened, you're not in contempt territory just yet. Hold on. Step 2, the court orders a contempt hearing. If one of those triggers is met, the court can then order the debtor to appear at a contempt hearing. The clerk of the court provides you with a notice of contempt hearing, which sets out the time, the date, and the place of the hearing. Step 3, you serve the notice. This is your job as the creditor. You have to serve the notice of contempt hearing on the debtor, and you have to file proof of that service at least 7 days before the hearing date. Don't miss this. If the service isn't done properly, the contempt hearing can fall apart before it even starts. You don't want to get into that. Step 4, the debtor's off-ramp. The rules give the debtors a chance to diffuse this before the hearing. Under Sub-Rule 20.114, the debtor can bring a motion, in other words, a formal request to set aside the order for the contempt hearing. They can do that before or after they receive the notice, but they have to do it before the hearing date itself. If the court, though, grants the motion, the contempt hearing doesn't just go ahead. Instead, the debtor is ordered to attend attend a fresh examination. Note that this only applies to a debtor who failed to attend the examination, not to a debtor who showed up but refused to answer questions. So in some cases, the threat of a contempt hearing is enough to get the debtor to come back for the examination hearing. That alone can be useful. Step 5, the hearing itself. If the matter does go ahead and the court takes contempt seriously, and what happens at the court hearing depends on what track the debtor is on. If the debtor is there because they showed up to the examination but refused to answer the question, then the framework here is what's called show cause. That means the burden is on the debtor to explain why they shouldn't be held in contempt. If they can't give the court a good reason, the court can find them in contempt. If the debtor is there because they didn't show up to the examination at all, then the hearing is governed by Section 30 of the Courts of Justice Act, which sets out its own requirements the court has to be satisfied of. Either way, contempt is treated as a very serious matter. Courts have consistently said the case has to be proven beyond a reasonable doubt, the same kind of standard that you'd actually see at a criminal trial, and any doubt is reserved in the debtor's favor. Step 6. What the court can actually order. If the court is satisfied, Subrule 20.117 gives the judge 4 options. The judge can order the debtor to attend a fresh examination under Rule 20.10. The judge can jail the debtor for a period of not more than 5 days. The judge can order another contempt hearing on a future date, or the judge can make any other order the judge considers necessary or justified. So the jail is one of 4 options. It's not the default, and the maximum is 5 days. Step 7, the warrant of committal. That's the Form 20J. If the judge does order jail, the actual paperwork that gets issued is called a warrant of committal. And I just want to spend a minute on this form because if your matter ever actually gets here, it's worth understanding what it actually says. The warrant is addressed to all police officers in Ontario and to the officers of all correctional institutions in Ontario. So it's not directed at one particular police service, but any police officer in the province has authority under this warrant. The body of the warrant identifies the debtor by name. It then checks off one of 2 boxes, mirroring the 2 triggers we covered in step 1. So that's either the debtor willfully failed to attend the examination hearing as required by a notice of examination that was properly served, or the debtor attended the examination hearing but refused to answer questions or produce documents or records and failed to show cause why they should not be held in contempt. The warrant then states the number of days the debtor is to be detained, and it directs the police to then take the person to the nearest correctional facility, institution, and admit them. You, as the creditor, can also fill out an identification form. That's the Form 20K to help the police actually find the debtor. That's optional, but practically useful. Step 8, how long the warrant lasts. The warrant is in force for 12 months from the date of the issue. After that, it expires, but it can be renewed for another 12 months at each renewal by order of the court on a motion you bring as the creditor. Step 9, all about the discharge. If the debtor is taken into custody, they're discharged either when the time on the warrant expires or by an order of the court, whichever comes first. That is Rule 20.11, from beginning to end. Part 3, the big caveat. I told you at the start I was going to be very straightforward about what a contempt can actually do and cannot do. Here's the part that I want you to remember the most, okay? Contempt of court in small claims court is about the debtor's conduct in the examination process. It is not about whether they have actually paid the judgment. So if your debtor just won't pay, that on its own is not enough. You have to be able to point to the conduct in the examination process. That is your doorway. And remember, Rule 20.11 is a tool for dealing with debtors who refuse to engage with the examination process. It is not an actual tool for collecting the money. Part 4, the honest assessment. So let me put this in very plain terms. If the other side just won't pay your small claims judgment, contempt is not the tool that will make them pay. The law doesn't allow it to be used that way. What contempt can do is actually enforce the examination process. If you serve a debtor with a notice of examination and they don't show up, or they show up but won't answer, that's where contempt actually has the teeth. All right. Practically, the realistic uses of contempt for a creditor, whether you're a landlord, a tenant, or anyone else who has converted an LTB order into a small claims judgment, look like this. 1. It can bring a debtor to the table. Sometimes the threat of a contempt finding is enough to produce a structured payment plan or to get the debtor to actually show up and answer your questions. 2. It can keep the file alive. Even when a judge is skeptical about the foundation, the next hearing gets scheduled and the process just keeps on moving. That matter stays active. The debtor keeps having to deal with it. I mean, don't let them get away with it. 3, in the most extreme cases of evasion, it can result in a warrant of committal. That's the Form 20J, but you should not assume the warrant will translate into an actual arrest quickly. In closing, what I need to tell you is that contempt of court in small claims is a real procedure with the real teeth and the real limits. Those limits exist for important reasons. But before you spend the time and the money on a contempt path, ask yourself the right questions. The right question isn't, can I get them in trouble for not paying me? The question should be, is the debtor refusing to engage with the examination process? And if so, that would be my best path forward. If you'd like help thinking through your enforcement strategy and the tools available to self-represented litigants in Ontario's Small Claims Court, you've got to check out my friends at courtready.ca. Their resources are free and you're going to learn a ton. Thank you for watching, and I'll see you in the next video.